presentation is an overview of the California Special Investigative Unit requirements from the perspective of the California Department of Insurance SIU compliance auditors. It is intended to take the mystery out of the audit and give insurers the information necessary to operate an SIU in compliance with the California SIU statutes and regulations. This video should be used in conjunction with other training. It partially satisfies the New Hire Orientation, Integral Anti-Fraud Annual, and SIU continuing training requirements. Nothing about this video presentation or its contents limits or diminishes an insurer's obligation to comply with all California SIU statutory and regulatory provisions. The California Department of Insurance conducts several types of audits and examinations of insurers. Each type of audit or examination has specific objectives. The audits conducted by the SIU Compliance Review Program specifically reviews the insurer's SIU to evaluate compliance with the California SIU statutes and regulations. The mission of the CDI Fraud Division is to protect the public and prevent economic loss through the detection, investigation, and arrest of insurance fraud offenders. To accomplish this, CDI partners with the insurance industry, other law enforcement agencies, and county district attorneys' offices. To be successful in this mission, we need insurers to be fully committed to fighting insurance fraud. CDI SIU Compliance Review Program auditors are part of the Fraud Division. We audit insurers conducting business in California to evaluate whether there is an SIU established that is compliant with the California statutes and regulations. The SIU auditors conduct on-site audits nationwide and analyze the information provided in the SIU annual reports filed by approximately 1,200 primary and subsidiary insurance companies each year. In addition, the auditors provide training to insurers on California SIU statutes and regulations, promote the identification, investigation, and reporting of suspected insurance fraud, and increase awareness of insurance fraud. SIU auditors are also a resource to insurers. We welcome questions about California SIU compliance and the completion of the California SIU annual report. When in doubt, please contact us. We have an email box specifically set up for questions about the SIU annual report. The CDI has statutory and regulatory authority to conduct examinations of an insurer's SIU and related operations, including operations undertaken by entities under contract with the insurer. The Insurance Frauds Prevention Act requires all insurers licensed to conduct business in California to operate an SIU that investigates possible fraudulent claims by insureds or by persons making claims for services or repairs against policies held by insureds. However, there are 7 exceptions: reinsurers, title insurers, fraternal fire insurers, fraternal benefit societies, firemen, policemen, or peace officer benefit and relief associations, grant and annuity societies, and home protection. Regulations establish requirements for insurer SIUs. SIU is knowledgeable and adequately staffed. SIU and integral anti-fraud personnel written procedures are maintained and include all required topics. Insurance transactions with red flags are referred to SIU. SIU investigations comply with California SIU statutes and regulations. Referrals to CDI are accurate, timely, and complete. Required anti-fraud training must occur and be properly documented. SIU annual report is accurate and submitted timely. Information requests from CDI, district attorneys' offices, and other authorized governmental offices are responded to timely, i.e., 60 days for workers' comp and 30 days for all other lines. Non-compliance with all of the above, including information requests that are not responded to timely, will result in penalties as required by California SIU statutes and regulations. Insurers that do not comply with the California SIU statutes and regulations, including not responding timely to information requests from CDI and other authorized law enforcement agencies, will be assessed penalties in accordance with California SIU statutes and regulations. Up to $5,000 for each inadvertent act of noncompliance, and up to $10,000 for each willful act of noncompliance. Insurers are required to continuously maintain an SIU unit or division to investigate suspected insurance fraud. The insurer's SIU may be internal or external, may be a distinct unit or division, or SIU duties can be assigned to employees whose principal responsibilities are the investigation and disposition of claims. The adequacy of an insurer's SIU staff shall be determined by its demonstrated ability to comply with California SIU statutes and regulations. Insurers have been required to have an SIU since July 1, 1992. The SIU shall have the knowledge and ability required by regulations. Employees must have knowledge and/or experience in general claims practices, the analysis of claims for patterns of fraud, and current trends in insurance fraud, education and training in specific red flag events, and other criteria indicating possible fraud. Employees must have the ability to conduct effective investigations of suspected insurance fraud and be familiar with insurance and related law and the use of available insurer-related data resources. Insurer integral anti-fraud personnel are the first line of defense against insurance fraud. Their knowledge of red flags and the SIU referral process is critical. Integral anti-fraud personnel is defined by California SIU regulations. They may include claims handlers, underwriters, policy handlers, call center staff within the claims or policy function, legal staff, or other insurer-employee classifications performing similar duties. Integral anti-fraud personnel are not directly assigned to the SIU. Bottom line, this is anyone who is or may be involved with the processing of an insurance transaction. Regulations require that there are written procedures specifically for integral anti-fraud personnel. During a recent audit, we found that the insurer's integral anti-fraud procedures contained information on how to detect and identify suspected insurance fraud. However, the procedures did not provide any guidance on how to document and refer the claim to the SIU. The procedures must address all four of these topics. The regulations specifically identify 5 elements that the written procedures for integral anti-fraud personnel must contain: patterns or trends of possible fraud, red flags, events or circumstances present on a claim, behavior or history of persons submitting a claim or application, and other criteria that may indicate possible fraud. During SIU audits, we have often found that insurers' procedures simply restate the regulation. This is not acceptable. The procedure must explain the process used by the insurer to carry out the regulatory requirement. The regulations specifically identify 5 required elements of an insurance fraud investigation. An investigation of suspected insurance fraud shall include a thorough analysis of the claim file, application, or insurance transaction, identification and interviews of potential witnesses, utilization of industry-recognized databases, preservation of evidence, a concise and complete summary of the investigation, including the investigator's findings and the basis for their findings. A frequent audit finding is that there is not a concise and complete summary of the investigation, including the investigator's findings and basis for the findings. Here are examples of effective methods of detecting and investigating insurance fraud. Establish, maintain, distribute, and monitor procedures to all anti-fraud personnel. Establish, maintain, distribute, and adhere to SIU investigative procedures. Proactive and aggressive approach to fraud detection and investigation. Here are examples of ineffective methods of detecting and investigating insurance fraud. No written integral anti-fraud personnel and/or SIU procedures. Procedures are outdated. Procedures are not fully compliant with California SIU regulations. Reactive approach to fighting fraud. Waits until losses are incurred. Does not investigate. Regulations set forth 4 specific requirements when referring suspected fraud to CDI. The suspected fraud is referred to the CDI Fraud Division, and for workers' comp, there is a dual reporting requirement to also refer to the California County District Attorney's Office. Referral shall be submitted where there is a reasonable belief of insurance fraud. Referral shall be made within 60 days of determining reasonable belief. This does not diminish statutory requirements contained in the Insurance Frauds Prevention Act regarding confidentiality of any information provided in connection with an investigation. Please note, regardless of application or claim status, or whether the insurer has filed a civil action, the suspected fraud must be referred to CDI timely. For workers' comp, there is a dual reporting requirement to the District Attorney's Office. If you refer to the CDI Fraud Division through the NICB website, the entire California section must be completed at the end of the form. The referral to CDI is not complete until the system generates a CDI case number, not just an EFD1 ID number. The referral must be complete to trigger the system to automatically forward the referral to a CDI fraud investigator. To the CDI investigator, the three most critical pieces of information are 1. A complete and concise synopsis, 2. Loss amount, 3. Loss locations. If you have not done so, it is in the insurer's best interest to register for the CDI electronic referral system, known as the EFD1 system. Referral errors and omissions and associated non-compliance penalties are significantly reduced when insurers use the electronic referral system to CDI. Therefore, CDI is helping all insurers register for the EFD1 system and will gradually phase out the paper referral form process this year. Here are examples of how to effectively report fraud to CDI. Reports to CDI upon reasonable belief of fraud. Uses current FD1 or EFD1 forms and codes. Provides complete and concise synopsis with sufficient facts and detail. Reports to CDI within 60 days of reasonable belief. Maintains contact with the CDI fraud investigator at the appropriate regional office. Here are some examples of ineffectively reporting fraud to CDI. Does not report to CDI at all. Does not report to CDI until the SIU investigation is completed. Outdated paper forms and/or codes. Suspected fraudulent claims contain errors and/or omissions. Synopsis does not provide sufficient facts. Does not respond to CDI fraud investigator inquiries timely. For all insurance lines except workers' comp, insurers have 30 days to respond to information requests from CDI, county district attorneys' offices, and other governmental law enforcement agencies. For workers' comp, insurers have 60 days to respond to information requests. A number of recent SIU audits were initiated because the insurer was not cooperating with CDI or DA requests for information. It is incumbent that the insurer respond timely or request an extension. Regulations require an insurer's SIU to establish and maintain 3 levels of anti-fraud training. New hire anti-fraud orientation training, integral anti-fraud personnel annual anti-fraud training, SIU personnel continuing anti-fraud training. Audit findings in the area of training are fairly common. Either the training material does not address all required topics, or all required staff do not receive the required training. In either case, this creates an internal control weakness regarding fraud detection. New hire training must be provided to all integral anti-fraud personnel new hires within 90 days of commencing duties and contain the 5 elements required by regulations. The SIU is responsible for the insurer's anti-fraud training program. New hire training must include the function and purpose of the SIU, an overview of fraud detection and referral of suspected fraud to the SIU, a review of CDI Fraud Division reporting requirements, an organization chart for the SIU, SIU telephone numbers. Integral anti-fraud personnel annual training must be provided to all integral anti-fraud personnel and contain the 6 elements required by the regulations. Function and purpose of the SIU, written procedures for identifying, documenting, and referring suspected fraud to SIU, identification and recognition of red flags or red flag events, changes to current procedures for identifying, documenting, and referring suspected fraud to SIU, CDI Fraud Division insurance fraud reporting requirements, introduction and review of existing and emerging insurance fraud trends. SIU personnel continuing anti-fraud training must be provided to all SIU staff and contain the 5 topics required by regulations. Investigative techniques, communication with the CDI Fraud Division and other authorized governmental agencies, fraud indicators, emerging fraud trends, and legal and related issues. Regulations specifically require the new hire, integral anti-fraud, and SIU training to include the 5 elements required by regulations. Title and date of the training course, name, title, and contact information of the instructor, description of the course content, length of the training course, names and job titles of participating personnel. Records shall be prepared at the time that training is provided to be made available upon a CDI's request. Here are examples of effective anti-fraud training. Anti-fraud orientation is provided to all new hire integral anti-fraud personnel within 90 days of commencing assigned duties. Annual anti-fraud training provided to all integral anti-fraud personnel. SIU staff completes continuing anti-fraud training courses. Maintain adequate and complete training records. Here are examples of ineffective anti-fraud training. Training does not cover all topics required. Anti-fraud orientation not provided to integral anti-fraud personnel new hires. Annual anti-fraud training not provided at all, or only to some of the integral anti-fraud personnel. No system to ensure all integral anti-fraud personnel receive anti-fraud training. SIU does not receive continuing education. Lack of or incomplete training records. Examples of effective anti-fraud training. Insurer keeps informed of current regulatory and reporting requirements, fraud alerts and red flags, updated procedures, fraud referrals, emerging fraud trends, detection methods. Insurer works with CDI for training purposes as well as investigations. Examples of ineffective anti-fraud training. Insurer not aware of new regulations or statutes. SIU does not keep abreast of fraud trends, detection, or use of databases. SIU does not train or share information with integral anti-fraud personnel. Insurer does not interact with CDI or other authorized agencies. Insurers licensed to conduct business in California are required to submit an electronic SIU annual report to CDI. CDI must provide notification to insurers in June, and the insurers must submit the report in 90 days. In 2014, the CDI hopes to give insurers the option of filing their 2013 California SIU annual report early. The report must be signed by an officer of the holder of, or applicant for, the California Certificate of Authority, and the insurer is required to keep the wet ink signature page for at least 5 years. The 2 most common audit findings related to the SIU annual report is omitted information or inaccurate statistics. Fairly common omitted topics are TPA and contract SIU information. A common inaccurate statistic we often see is the number of SIU referrals. We have found that insurers sometimes include SIU referrals that were not suspected fraud, such as claim assistance for more complex claims. Here are examples of compliant SIU annual reports. Submit complete and accurate report timely. If using a contracted SIU, TPAs, general agents, or MGAs, include the contract. Contracts contain all required information. Statistics include information from the primary insurer and subsidiary insurers, and TPAs, general agents, or MGAs. Here are examples of non-compliant SIU annual reports. Incomplete or inaccurate report. Fails to provide contracts for external SIUs, TPAs, general agents, or MGAs. Fails to indicate how contracted SIU is monitored. Fails to submit annual report timely. There are 2 types of SIU audits that CDI performs. On-site audits, which focus on all aspects of the insurer's SIU operations, and limited scope audits, which currently focus on A. SIU contracts, B. Written procedures, C. Training material and training records content. These audits may be modified to address any other areas where the risk of non-compliance may exist. Insurers are selected for an SIU audit based on several factors, including the following: SIU annual report review, quantity and quality of referrals to CDI, lines of insurance, market share, lack of timely response to information requests from CDI and other authorized governmental agencies. Commissioner's priorities. Referrals from within or outside of CDI. Typically, a field audit takes 1 week on-site. The CDI auditor typically contacts the insurer 8 weeks in advance to arrange mutually agreeable on-site dates and locations. This is followed by an engagement letter and documentation request. Some documents are required to be provided to us 30 days prior to the on-site visit. Other documents are required to be provided at the beginning of the on-site visit, and other documents may have been previously provided with your most recent SIU annual report. It is in the insurer's best interest to provide all requested documentation timely, which includes full system access at the beginning of the on-site visit. The on-site visit consists of an entrance conference, analysis and testing of insurer documentation, and closes with an exit conference. Potential findings are discussed at the exit conference. The on-site visit is followed by the release of a preliminary or draft report approximately 3 months later. The insurer has 30 days to provide a corrective action and compliance plan, or CACP, in response to the findings contained in the preliminary report. Insurers are encouraged to work with the CDI audit team when writing their CACP. A final report is issued at approximately 60 days after receipt. The CACP for each finding is reviewed by the CDI audit team and is either accepted or rejected. Rejected CACPs may subject the insurer to penalties. Here are the documents that the CDI audit team will typically look at to determine compliance with statutes and regulations. Anti-fraud documents and other information are examined prior to, during, and after the on-site visit. SIU staffing and performance. Written anti-fraud procedures for integral anti-fraud personnel. Written procedures for SIU investigations. New hire anti-fraud orientation training for integral anti-fraud personnel. Annual anti-fraud training for integral anti-fraud personnel. Continuing anti-fraud training for SIU personnel. Closed California claims. SIU investigation files. EFD1, FD1 suspected fraud referrals to CDI. SIU annual report. CDI and DA information requests and the timeliness of insurer response. Insurers have the option to contract with external SIUs, TPAs, general agents, and MGAs to conduct business on their behalf. But if they are conducting SIU functions, these operations are subject to audit. The insurer is responsible for ensuring its employees and the employees of any subcontractors comply with California SIU statutes and regulations. The term or label an insurer uses to describe its relationship with another entity is not relevant. Whether the insurer call them a TPA, MGA, or partner, it does not matter. What is relevant is whether the other entity is providing either 1. SIU services, or 2. is providing integral anti-fraud personnel services, such as claims processing or underwriting services to the insurer. If yes, you are responsible for the other entity's compliance. Blanket compliance statements in a contract such as the TPA or MGA must be responsible for all compliance issues does not go far enough. The subcontractor's actual operations, training material, and procedures will be accessed to determine compliance. Here are examples of acceptable responses to audit findings and recommendations. Recognize non-compliance. Be willing to implement recommendations. Respond timely and completely. Cooperate with the auditors. Here are examples of unacceptable responses to audit findings and recommendations. Does not take prompt corrective action to resolve non-compliance. Attempts to defend deficient SIU practices. Does not adequately address findings and recommendations. Does not respond timely. Insurers are the first line of defense against insurance fraud. We value our partnership with the insurance industry. Together, we make a difference in the fight against insurance fraud. We hope this video has been informative. Thank you for your participation. We hope this video has been informative. Thank you for your participation.